Good morning, everyone, and welcome to the spring edition of the Kuits Commercial Property webinar. I'm your host, David Moroney, a partner in commercial property, and I apologise for the informality of my address. However, I've been brought off the bench today due to Sally Knight unfortunately not being available. As a consequence, we'll be omitting from this webinar Sally's section on service charge recovery from litigation costs. What we will be covering today, however, are rights of light with my commercial property partner, Tim Arkwright, Economic Crime and Corporate Transparency Act with my corporate partner, Helen, and lease renewal opposition on the grounds of redevelopment with my commercial property colleague, Stacey Rees. So without further ado, I will hand you over to Tim, who will commence with rights of light.
Hi, everyone. Rights of light has obviously been quite a hot topic for quite a while now. I'm sure many of you will be aware of the potential issues when undertaking developments, but some of you may not. It's potentially relevant in any situation where a building owner seeks to construct a new building or increase the height of an existing building. Essentially, if a new building or an increase in the height of an existing building either blocks or reduces the light reaching neighbouring buildings, there could potentially be an issue. So I'm going to give a short overview of the position. So the things I'm going to cover are what is a right of light and what is it not? How is a right of light acquired? What are the problems, basis of any claims? And how do you defeat any claims and what are your remedies? And finally, what is a decent strategy for developers? So firstly, what is a right of light and what is it not? So it's a right to receive light through defined apertures in buildings. So the obvious one there is windows, but it could also be skylights and potentially even sort of patio doors. The right is sufficient light for the comfortable use and enjoyment required for ordinary residential or commercial purposes, according to the ordinary notions of mankind. It can benefit both the freeholders and the tenants, provided they've built up enough rights. But what it isn't is a right to a view, or a right to privacy, or indeed a right to sunlight. It could be artificial light that you could be getting, which could be enough, and it could be reflected light from another building. It's also not a general right to light across your property. Very specifically, it's only the defined apertures. So next, how is a right of light acquired? Well, there are several ways. There's express grant by deed, which is relatively rare. In fact, the first three there are all relatively rare. The statute and lost modern grant, but the most common is via the Prescription Act 1832. So that states that unless enjoyed by written consent or agreement, actual enjoyment of light through defined apertures for 20 years without interruption creates an absolute and indefeasible easement. So if your neighbour or if a neighbour has enjoyed light for 20 years, then generally speaking, in the first instance, they'll have a right. So what are the problems and basis of claims? Well, in terms of claims, there's two issues. There's injunction and damages. So obviously with an injunction, if the building that you're constructing is sufficiently interfering with neighbouring properties, then they can apply to the court for an injunction, which if the development has already commenced or it hasn't started yet, then the court can order that it be halted. And even in a worst case scenario, if you've already completed your development, the court can order that the infringing part be demolished. So that could be the whole building, or it could just be a part. So that's obviously pretty catastrophic for developers. Slightly less so, and what most developers hope will be the case, are damages. So in many cases, neighbours will not necessarily be wanting to go to all the hassle of an injunction, but they will just want some money. So damages are based upon the multiple of the book value, which is basically a capitalized loss of light by reference to the yield and a notional rent for the loss of light. So usually there's an enhanced amount payable depending on the severity of the breach and the relative bargaining positions of the parties. So in sort of Manchester, it can be often 1 to 3 times book value, but in London, it can be up to 10 times book value. The case law on this has changed numerous times over the years, and until fairly recently, the developers were generally okay because the courts were tending to award damages rather than injunction. But in the last 2 or 3 years, there's been a case in particular which has slightly reversed the position. So the courts are now on the basis that the primary remedy is an injunction rather than damages, which is not great. So problems with this, well, obviously the injunction one and stopping your development is the major one. But even if it was damages, then it can be time consuming and costly. So time consuming in terms of identifying whether there's any rights of light, assessing the effect and the how bad it is and the cost. And then obviously you've got to negotiate with the neighbouring landowners potentially, and then document any deed of release of those rights to light, which can all take quite a lot of time. In terms of costs, well, obviously you've got compensation or damages itself, any court fees, but then generally you're also expected to pay the neighbours, surveyors and solicitors fees for negotiating and documenting any remedy. And there's also, of course, the delays in construction. That not only increases your finance costs, but it delays the time when you can actually get going with selling. So then how do you potentially defeat any claims? Well, the first one, I suppose, is to check the deeds carefully. Often when a piece of land has been sold out of a larger plot, the landowner, the selling landowner, will exclude any rights to light in the deeds from the piece of land that's been sold off. So if the neighbouring piece of land was one of those pieces that was sold off, then it may be that the deeds contain a specific exclusion preventing any rights of light. There's various wordings. Some of them are around consent. If you consent to it, then it's not a right, and also a license. But you do need to be careful when you check the deeds, because quite often it will effectively cancel any rights to light at the point the deed is entered into, but it won't necessarily prevent any future rights from being established. And obviously the Prescription Act allows it 20 years, so it could be that 20 years later a right has arisen again. The next one is interruption before the right's established. So if there is 1 year interruption of the light, then that prevents the right from being established. So essentially that means that if you can get your increase in height or new building put up within the first sort of 19 years, then that puts an end to it. The third one is light obstruction notices. So back in the old days, a long time ago, people used to put up what are called spite screens, which was a physical barrier along the boundary between the two properties, which effectively blocked the light to the windows of the neighbour so that they couldn't then claim rights to light. It's obviously not an ideal situation. So the Rights of Light Act 1959 introduced the concept of light obstruction notices, which effectively puts an imaginary barrier along the boundary, which can be as high as you want, or even infinite height, which has the same consequences as a physical obstruction. So the application involves an application to the court, service of notices on the affected neighbours, and then registration as a local land charge. By a slightly strange quirk of that act, I think it's probably a drafting error, you're advised to get any light obstruction notice served within the first 18 years rather than 19. It appears that if it's after 18, there's some question of whether it'll still be valid. The fourth one is whether the interference is substantial or not. If it is only a small amount of interference and it doesn't reduce the light enough, then that will mean that there potentially can be no claim. And the fifth one is Section 203 appropriation under the Housing and Planning Act 2016. So essentially, if the council considers that development is strategically important enough, then they can enter into a sort of development agreement, JV agreement with the developer, whereby, subject to certain conditions and provisions, statutory provisions, they can acquire the land, and then they will grant a long lease to the developer and then appropriate under Section 203. This has the reality of removing the injunction risk, so any neighbours can no longer apply for an injunction. It doesn't remove the damages and compensation risk. So if a neighbour has genuinely suffered a loss because of the interference, then they are compensated for that loss. But often damages are much higher because of the risk of injunction, because obviously the neighbours know that the developer doesn't want to have a lengthy court battle, and therefore they will pay them off at a higher amount than their strict loss. So removing the injunction risk effectively takes away that. So it can mean smaller damages based on injurious affection, which is just the actual loss. So what is the strategy for developers? Well, I suppose the first thing is if you're intending to develop and increase the height, then you should instruct a specialist surveyor as soon as possible who will use computer software to model the development, and they will check old plans, etc., to assess whether there are any neighbouring apertures likely to be impacted, and obviously when those buildings were constructed to see whether they are within the last 20 years, essentially. And they will also calculate any potential damages payable. If that proves that there may be a claim, then you should instruct solicitors to check the title of the development and the neighbouring land for consents and any rights to light exclusions. Obviously, we'd be more than happy to undertake that on your behalf. If that still indicates that there's a potential claim, then you may consider changing the development profile to minimise the interference. Obviously, if it's still at the pre-construction stage, then it may be possible to just slightly amend the development so as to remove the interference. There's also obviously the potential for light obstruction notices if your development is coming up to sort of 18 years, but it's not got there yet. That can be very useful. And then the common one, to be honest, is rights of light insurance, which a lot of developers take out, and you may well be to take that out in conjunction with some of the other elements there. And indeed, funders often want to see there's a rights of light insurance in place, and that insurer may or may not want you to negotiate with landowners depending on all the circumstances, basically. But obviously, if you are going to negotiate with landowners, with the neighbouring landowners, then you need to try and get going with that as soon as possible, because it can take time. And then obviously, if circumstances are right, then consider using Section 203 if that's appropriate. But it's not always going to be the case. So anyway, that concludes my whistle-stop tour through rights of light. Hopefully you found that useful. Obviously, if you've got any queries on that, then please feel free to call me or contact me here at Kuits, and we'll do our best to assist. So I'm going to pass on to Helen Mather for her talk on what is the Economic Crime and Corporate Transparency Act 2023. Many thanks.
Good morning. So the Economic Crime and Corporate Transparency Act 2023, or ECTA for short, is a new piece of legislation that forms part of the government's wider strategy to reduce economic crime in the UK. It includes a wide range of reforms that will affect all companies, as well as also affecting LLPs and limited partnerships in various ways. I'll focus on companies in this webinar. ECTA is coming into force in stages. Parts are already in place, but the rest will be implemented over time. The overall timetable for implementation and some of the detail of the requirements and obligations are unclear, as further legislation is required to clarify them, but it's expected many of the changes will be implemented in 2024. We don't have time to go through or even to mention all of the changes ECTA is bringing in today, but to give you an idea of some of the things it covers, the reforms include reforming the role of Companies House. So it's bringing in identity verification requirements for directors of companies and persons with significant control of a company, amongst others. It's already introduced new powers Companies House have to require additional information, remove or reject information that has been filed, and to impose fines and criminal sanctions. Companies House can now also analyse and disclose information provided to it to any person or public authority for the purposes of crime prevention or detection. Companies House are essentially now expected to be actively involved in preventing economic crime. And ECTA will also be changing how documents can be filed at Companies House and who can file them. Other changes outside of the changes to Companies House include changes to the law on corporate criminal liability for economic crimes, so that actions of senior managers can result in a company being criminally liable. New powers to seize and destroy crypto assets which are involved in crime. A new corporate failure to prevent fraud offence, which will not come into force until the government has published statutory guidance relating to the offence. But we do already know that it can only be committed by large organisations. It will be a defence for a company to prove that it had appropriate prevention procedures. It's expected that that will be similar to the Bribery Act defence in a lot of ways, but this remains to be seen. And of particular relevance in the commercial property sector, ECTA is introducing changes to the Register of Overseas Entities regime, which you may already know is a register that records overseas entities that own certain land in the UK and the beneficial owners of those entities. Some of the reforms that are already in force are, since December 2023, the changes to the law on corporate criminal liability for economic crimes was introduced. Since the 4th of March 2024, some of the changes relating to the Register of Overseas Entities, which we'll talk about a bit more shortly, were introduced, and various of the reforms relating to Companies House's new powers and some of the new corporate filing requirements were brought in. For example, if you filed an annual confirmation statement or incorporated a company recently, you may have noticed that a company's registered office must now be confirmed to be an appropriate address, which is an address where delivery can be acknowledged and comes to the attention of a person acting on behalf of a company, and specifically not a PO box. Similarly, companies must now notify Companies House of and maintain a registered appropriate email address for communication with Companies House. There's also now a requirement for all shareholders forming a company to confirm on incorporation that they are forming the company for a lawful purpose, and on their confirmation statement that the company's future activities will be lawful. And since the 2nd of May 2024, increases in Companies House fees have taken effect, which I'm sure won't come as any surprise, given they've obviously got to fund all these new functions and responsibilities somehow. As one of the most anticipated reforms under ECTA that is not yet in force, I want to focus for a short moment on the obligation that all directors and persons of significant control of a company will be required to verify their identity at Companies House unless they're exempt, which might be for national security reasons, for example. The details around the process of identity verification have yet to be published, but it's likely to be through a digital service that links a person with a passport or driving license. It would be an offence to continue to act as a director if the identity of the director has not been verified. The Register of Overseas Entities, you may already be aware, is held at Companies House in respect of overseas entities which own freehold interests or leases of more than 7 years in the UK, and contains information on their beneficial owners, essentially the ultimate owners of more than 25% of shares or voting rights, or those with significant influence or control over the overseas entity. Overseas entities are generally prohibited from disposing of its property in the UK unless the entity is a registered overseas entity, and the requirements for updates to information are complied with at the time the disposition is made. ECTA brings in some new or extended changes to the overseas entity register regime. Some of these changes are already in force, including, firstly, that the changes changes intended to close loopholes in original overseas entities register legislation that came under criticism, and to reach a position where the true beneficial ownership of UK land is to be reported, with additional requirements relating to ownership by nominees or trusts, so that the details of the trustee and information about the trust have to be notified on the overseas entities register, no matter where they sit in the chain of ownership. And for cases involving the holding of land by a nominee, the person on whose behalf the land is held will be treated as the beneficial owner and will therefore need to be registered. Secondly, also in force is a new process whereby Companies House can now issue a notice to the overseas entity to require it to provide information to enable Companies House to identify whether statutory obligations to deliver documents to Companies House have been complied with, or whether information contained in documents delivered to Companies House should form part of the overseas entities register. Where a notice has not been complied with, the overseas entity will no longer meet the criteria of a registered overseas entity, and therefore it will not be able to deal with its property interests in the UK. This means that parties transacting with an overseas entity in a property transaction will need to continue to ensure that they are confident that the registered status of that entity is compliant, to ensure that the land registry will accept the transfer or registration of a lease or land. It isn't clear yet how counterparties will actually be able to establish whether an overseas entity has failed to respond to a notice from Companies House, as it is expected that this information will not be made publicly available. Inquiries with Companies House are ongoing, but in the meantime, transaction documentation should include appropriate warranties in this regard. There are some other administrative changes relating to the process of filing the information on the register, and penalties and offences for failing to comply, to give the regime's requirements more teeth generally as well. So in conclusion, it's important that all companies are ready for each stage of implementation of ECTA, because non-compliance in most cases is a criminal offence by the company and its officers. The penalties for non-compliance can be quite severe. For example, directors can be disqualified if they have had 3 or more breaches of companies' legislation, including non-compliance with filing obligations at Companies House. Many of the offences carry unlimited fines as the penalty, and some can actually result in imprisonment. There is a lot more to ECTA than that I've touched on today, and given the wide range of reforms and that many of the changes are not yet fully understood, it's understandably difficult for business owners and managers to keep on top of the changes and the obligations that come with them. Companies should firstly make sure that their directors and relevant managers are aware of ECTA, and then that they are kept up to date. some things we could assist with from a practical point of view, for example, are providing you with a briefing note for your board of directors that will pull everything together, reviewing historic companies' house filings to ensure that they're compliant, and helping you draft policies and procedures to minimise your exposure, such as relating to the failure to prevent fraud offence. If you'd like any more information or have any questions around ECTA, then of course, please let me know. I'll now pass you over to Stacey.
Thanks, Helen. Good morning, everyone. Today I'm going to give you an update on a recent ruling on a county court claim that's decided a new and important point of law regarding the extent of the holding for the purposes of opposed lease renewals. So this will be of significant interest to both landlords and tenants, who will be questioning how widely applicable this ruling will be. So to briefly give you some background on the legislation that's been considered in this case. So under the Landlord and Tenant Act 1954, a landlord can oppose a lease renewal request from a tenant whose tenancy has the protection of security of tenure provisions under the legislation if certain grounds in the legislation apply, one of which is ground F. So ground F states that a landlord can oppose an application for a new tenancy if, on termination of that current tenancy, the landlord intends to demolish or reconstruct the premises comprised in what's known as the holding or a substantial part of that premises, and they intend to carry out substantial works of construction on the holding or part of it, and they can't reasonably do so without obtaining possession of that area. So the recent case considered by the County Court is the case of Sainsbury's Supermarkets and Medley Assets Limited. So the key facts of this case are that the tenant was Sainsbury's and they occupied supermarket premises on Kentish Town Road in London under a lease which was protected by security of tenure. So the premises under the lease included a ground floor supermarket area, basement and upper floors, and it's important to note here that the basement and the upper floors were actually vacant. So the landlord, so Medley Assets, served a Section 25 notice to terminate Sainsbury's tenancy on the 30th of July 21, based on redevelopment grounds under Section 30 of the Landlord and Tenant Act, i.e. ground F. Sainsbury's then issued a lease renewal claim in July 21, arguing that the landlord had not successfully satisfied the requirements for ground F, so they were entitled to a renewal lease. And the case then proceeded to trial in January of this year. So it's worth noting that there would be a later trial to deal with the terms of a renewal lease if Sainsbury's were successful. So under the Landlord and Tenant Act 1954, a tenant can renew the tenancy of the area that under the legislation is termed the holding. So for tenancies protected by the security of tenure, the area for the purposes of this holding will be the area that's actually occupied. So as such, a key point that the court needed to determine in this case concerned the extent of the holding and if the proposed works impacted on that area. So when determining the extent of the holding, the landlord argued that the holding should be the whole of the premises demised by the original lease. So that would be the basement, upper floors and ground floor stockroom and supermarket area. And they sought to rely on Section 32(2) of the Landlord and Tenant Act, which requires the tenant to take a tenancy of the whole of the premises demised in the existing lease. Otherwise, the tenant would be able to vacate certain areas before the trial to defeat ground F and then reoccupy those areas to obtain a renewal of the whole. Sainsbury's, however, argued that that section of the Act, so Section 32(2), would only be relevant when deciding the terms of the renewal lease at a later date. The holding should actually be the areas occupied only. So an important point to note here is that a week before the actual trial, Sainsbury's vacated the ground floor stockroom, so they actually only occupied the ground floor supermarket area as at the day of the ground F trial. The judge actually agreed with Sainsbury's that the holding for the purposes of ground F should be limited to the areas actually occupied as at the date of the ground F trial. So we'll come on to the full extent of the landlord's work shortly, but it was found that the holding, as determined by the court, was not actually an area that was affected by the landlord's works. So therefore, the landlord could not prove an intention to develop such holding, which is required for ground F, and Sainsbury's was successful in defeating the landlord's opposition claim. So interestingly, the court also considered if the works would have actually constituted redevelopment works under Ground F if Sainsbury's had actually occupied the area affected by them. So in relation to the actual works that were proposed, the Medley Assets as a landlord originally obtained planning permission to convert the upper floors of the building into residential flats. But by the time of the Ground F trial, their plans had changed and the intended works were to lower the basement floor and widen the staircase from the ground floor to the upper floors so that in the future they could redevelop these areas into office space. The factual evidence during the trial, however, established that the proposed scheme had only been devised after the Section 25 notice was served, and more than 2 years after the documents supplied to the court stated that the works would be finished, no practical steps had actually been taken to start the proposed works, despite the landlord having ample funds for them and already having secured planning permission too. So as to the viability of the works and the occupation of the tenant, the evidence proved during the trial that the proposed works did not add up to a realistic plan and they weren't actually deliverable in their current form. The tenant's expert's opinion was even that the works were not actually viable. There was also no suitable access route for the materials and machinery to the site, and the works would have actually breached building regulations in their current form, specifically in relation to fire escape guidelines. And in relation to occupation by the tenant, the ground floor proposed works could have actually been carried out without taking possession of the ground floor supermarket area too. So on the facts and the evidence, the judge found that the landlord did not have a genuine and settled intention to carry out the proposed works, nor did they seem to have any intention of actually going through with the works. The works as a whole didn't actually appear to be viable or deliverable. The proposed works to the ground floor staircase and stockroom were not substantial works of construction, reconstruction, or demolition as required for Ground F. Some of the works were actually outside the area of the original lease. And finally, that whilst the proposed proposed basement works were carried out, the tenant could have actually stayed in occupation and continued trading from the ground floor, and their demise would have been largely unaffected, other than a small storeroom on the ground floor. The judge also made a couple of interesting observations in relation to experts and the quality of the factual evidence that needed to be supplied to support a landlord's Ground F opposition claim. So the judge commented that in this case, the landlord's expert surveyor was unaware of his duties to the court and even went as far as saying that he was unreliable as an expert. The reasons for this included that his expert report contained many inaccuracies and errors. For example, there was 84 spelling mistakes and an inaccurate plan, which he refused to take responsibility for, even arguing during the trial that the errors were not in the report when he finalised it, which the judge later found to be untrue. There were also several inconsistencies in the expert evidence that he provided, which were highlighted by Sainsbury's legal team during the trial. And there was also several breaches of the court rules, which were not corrected once the surveyor was made aware of them during the trial or even before it. So consequently, the judge favoured the evidence provided to the trial by the tenant's expert surveyor. So to summarise, the key points to note from this case are that it appears that a tenant can temporarily vacate part of the premises affected by the proposed works to defeat a landlord's opposition claim. They can then return to that area of the premises before trial for the terms of the new tenancy and seek a renewal of the whole. The landlord's proposed works to lower a level of floor will not always be sufficient to satisfy Ground F. It will obviously depend on the terms of the facts of the case and whether the tenant will be able to stay in occupation of the premises once the works are carried out. Thirdly, that a landlord's intention to carry out redevelopment works must be a genuine and settled intention, and they must be proceeding towards carrying out those works, not simply stalling until the judgment of the Ground F trial is made. And also that experts who supply evidence must comply with their duties to the court rules and ensure that their reports are accurate, importantly, correcting any errors when they're made aware of them. So as a final note, if you're a landlord and tenant and you have any queries concerning any oppositions to renewals or leases at all, then please feel free to contact the team here at Kuits and we'll be happy to help. Thank you.
Thank you, Stacey. I'd like to thank all three of our speakers today for what I hope you all found were extremely helpful and informative presentations. We've had a number of questions which have been raised during the course of these talks, and I'm just going to touch on a small number of those now. Firstly, one for Tim, if I may. Whilst touched upon briefly, Tim, could you expand slightly on how much interference with rights of light would be classed as non-substantial?
Yeah, I mean, there's no fixed test, but historically the courts have called on expert evidence from surveyors to assist in assessing whether there's been an actionable interference. The main reliance sort of assessment is called the Waldron test, which is a technical methodology developed by Percy Waldron in the early 1900s. So that comprises two principles. Firstly, that the threshold of adequate light is 1 lumen of light at table level, which is effectively an area of 1 square foot by a candle burning at a height of 1 foot. The measurement is based on the whole sky, which is assigned the illuminating power of 500 lumens. So 1 lumen is 0.2% of the sky. So that's obviously quite a technical test. And that's usually done by sort of computer modeling, or presumably you can actually go into the property and measure it. The second principle is that a room may be regarded as adequately lit for ordinary purposes if 50% of it or more receives not less than 1 lumen of light at table level. Any reduction below 50% is generally regarded as potentially actionable. So this is known as the 50-50 rule. Again, it all comes down to computer modeling these days. Notably, it's not a question of how much the development reduces the light by, but how much is left. So it could be that there's only a small amount of interference, but if the rooms were poorly lit in the first place, but not actionable, then the slight reduction caused by the development could be enough to tip it into claim territory, and then obviously a claim can then be found. So I know that's slightly technical, but hopefully that answers the question.
Thank you, Tim. Very enlightening. Sorry, that was a lawyer joke, and I realised how awful it was when I said it. So moving swiftly on, Stacey, there have been talks of reforms to the Landlord and Tenant Act. Are there any ideas what those changes may be and when?
Yep, thanks, Dave. Yeah, that's right. There has been talk of reforms to the Landlord and Tenant Act. So in March 23, it was announced that there would be a review of the legislation of the 54 Act with a view to bringing it more in line with how business is done today and make it more modern. So a report on these 4 reforms was originally due in December of last year, but it's now been postponed until autumn this year. It's unclear what areas will be posed for reform, but the Law Commission will probably be looking at key areas of the Act. So, for example, the security of tenure provisions, especially as it's been almost 20 years since the last significant update was made to that. Also, the landlord's grounds to terminate a protected lease and regain possession. And also the notice procedures around the Act, which are seen to be very archaic and they slow things down. So yeah, it's expected that landlords and tenants will be watching closely when the report is published as to what reforms are going to happen and how they may impact them. Hopefully that answers that query.
Thank you, Stacey. Needless to say, if anybody has any further questions, either now, which they may think of after the event, please feel free to contact any of our speakers or anybody else at Kuits who will be delighted to assist you. So to conclude, I'd like to thank you all very much for attending today, and we look forward to welcoming you all to the next edition of the Kuits Commercial Property webinar. Thank you.